The broadcast is now starting. All attendees are in listen-only mode.
Well, good afternoon, everybody, and welcome to today's webinar. My name is Matt Godson, co-CEO with Momentum Names, and it's my pleasure to welcome you here for this afternoon session. Before I introduce today's presenter, just a couple of notes for everybody listening on this call. Hakun has agreed to make this session recorded and also enabled me to send everybody on this session a copy of the PowerPoint presentation subsequent to the conclusion of today's session. So in case anyone has any questions about whether the session is going to be recorded or whether there is going to be, the PowerPoints are going to be made available, everybody will receive a link from me within the next 24 hours, which will enable them to download the presentation and get an access to the recording. In addition, we will be having a Q&A at the conclusion of today's session. In order for you to participate in the Q&A, please use the question or chat panel, which is part of your GoToWebinar piece of software, which should be on the right-hand side of your screen. If you pose those to me, I will make sure that I pose them to the presenter at the conclusion of the webinar. With that being said, it's my pleasure to introduce you today to Hakun Wong from Fitzpatrick for today's session, Inter Partes Review versus District Court Litigation. Hakun, over to you.
Thanks very much, Matt. So first of all, thank you everyone for tuning in, and good afternoon. My name is Hakun Wong, and I'm a partner at Fitzpatrick, as you can tell from the heavy branding on my presentation. I've been working in intellectual property litigation for over 15 years now, and I found this pseudo-new IPR process, this inter-parties review process, to be particularly interesting with respect to patent litigation. So I'll be discussing with you today some of the characteristics of an IPR and comparing that with district court litigations, as well as discussing the impact that the two routes have on each other. Of course, I thought that inter-parties review versus district court litigation sounded a little bland, so I decided to spice it up a little bit by adding the subtitle cage match. Now, for those of you who don't know what a cage match is, you clearly missed out on the WWF when you were a kid, and I'm referring to the wrestling, not pandas. But perhaps I can provide you with an example. So here is an example of a cage match of sorts between former 1980s pop stars Debbie Gibson and Tiffany from the classic movie Mega Python versus Gatoroid. Yeah, I'm not exactly sure what a Gatoroid is either. But what's most interesting about this is, other than the fact that Deborah Gibson, as she goes by now, and Tiffany have resorted to B-rate sci-fi films, is that this is such a low-budget movie that they couldn't even get good extras. I mean, the waiters and the women on the left are basically not even acting at this point. The guy on the right looks like he's in a V8 commercial, and it kind of looks like the woman in purple decided to throw cake in her own face, which doesn't make a whole lot of sense. Well, the point is, though, other than the fact that I'll do whatever it takes to get a picture of Debbie Gibson and Tiffany into an IP presentation, this is also kind of like a cage match, so now you know what I'm referring to. Well, let me get back to IPRs. So here's an agenda for today, what we're going to be talking about in parts. So first I'm going to give you a little introduction on IPRs and what they are and a little bit about the process. And then I'm going to talk about the IPRs in conjunction with district court litigations. And we're going to talk about that in 4 different ways. One we're going to talk about is litigation stays in the face of pending IPRs. And then we're going to talk about the differences in the burden of proof. And because both these tracks run parallel to each other, what type of deference is due between the two venues. And then we'll talk a little bit about estoppel between the two venues. So we'll touch on a little bit of everything. And then we'll end off with a couple practice tips. So if you want to tune out for about 40 minutes of this, please, please, please tune in at the last 5 minutes so I can give you some practice tips. So this is a picture of the Avengers from the Avengers Age of Ultron opening on May 1st, which I'm very excited about. I am a huge fan of the Avengers, and that's okay now since comic books are so much cooler today than they were 20 years ago. And I guarantee that if I said that I was a fan 20 years ago, most of you wouldn't even speak to me again. But the other reason we're looking at this picture of the Avengers is because they are actually relevant to what we're discussing today. You know, the Avengers are pretty hard to define. I mean, in a vacuum, if I told you there's this awesome movie about a giant green monster, a Norse god, a superhuman soldier, some guy in a metal suit, and Scarlett Johansson, you'd either think that I was telling you some sort of joke, or you'd think that perhaps I should start seeing a psychologist. Well, joke's on you. I already have a psychologist, and I'm well aware that giant green monsters, Norse gods, and Scarlett Johansson are not real things. But the point is, IPRs, like the Avengers, are hard to define. They are USPTO process, but they have many similarities to full litigation. Let me see what I can do to kind of help you all understand a little bit more about IPRs. So in 2011, the America Invents Act created this inter-parties review, this IPR I've been talking about, to replace inter-parties re-examination, which I'm going to refer to as IPX. And you're probably asking yourself, well, what is an IPX? Well, an IPX is a USPTO, that's the United States Patent and Trademark Office, administrative proceeding to challenge the validity of patents that have already issued. In an IPX, a person challenges the patent by submitting a request to the USPTO. Now, this request must supply prior art references and make proposed rejections to the claims, and the request is assigned to a patent examiner in the Central Reexamination Unit, otherwise known as the CRU, of the USPTO. Now, the examiner then decides whether the request raises a substantial new question of patentability, and if so, it begins with the IPX proceeding. So if that's an IPX, what exactly is an IPR? Well, an IPR is actually relatively similar. It's a petition that you file with the PTO 9 months after the grant of the patent or later that requests the cancellation as unpatentable claims of that patent under 102 or 103 grounds, that is anticipation or obviousness. Now note that 101 and 112 grounds are not available. So whether it's patentable subject matter or not, or for instance written description issues, those can't be the grounds in which you file your IPR. Now, in case you're wondering what's going on with that 0 to 9 month period, since you can only file this 9 months after the grant, there is another process that the PTO allows, and that's called the post-grant review process, which is very similar to the IPR and is available during that 0 to 9 month period, but it does allow for 101 and 112 grounds. Now, we have only a limited amount of time today, so I can't spend a lot of time talking about post-grant review. Maybe next time we can chat about that. But so let's stick to IPRs. But I just wanted you to know what was going on in that 0 to 9 month period. So now that you know what an IPR is, you're probably asking yourself, well, what are the requirements for an IPR petition? No worries, I got you covered. So for a petition on IPR, you have to satisfy a few conditions. Now, the petition must be accompanied by the payment of the fee because the government needs to get its money. And the petition must identify all real parties and interests. Now, a petition for IPR does not require Gerber singles. Now, apparently in 1974, Gerber, yes, it's a baby food company, thought that single adults were super lazy. In fact, they thought that single adults were so lazy that they couldn't be bothered to pick up the phone and order a pizza, or heat up a frozen dinner, or apparently chew their own food. Now, that's just ridiculous. Now, I'm not that lazy, and I am pretty lazy. In fact, one article noted that this product might as well have been called "I'm single and I eat my food from a jar," which is always attractive when looking for a date. Anyway, thankfully, this was taken off the shelves pretty quickly, and it is not a requirement for your IPR petition. What is a requirement is that the petition must identify each claim challenged, the grounds, and the evidence, and that includes copies of the patents and written publications that you're relying on, affidavits or declarations supporting that evidence, including expert opinions, such other information as the director may require by regulation, whatever that is, and copies of all this stuff has to be provided to the patent owner or the designated representative of the patent owner. So now you know the requirements of what you need for the IPR. So you're probably wondering now, so okay, I know what an IPX is, I know what an IPR is, I know what I have to do to file each of those things. So what's so new about the IPR? Well, as we see, the IPR is essentially for the same purpose as the IPX, so that's why it replaces it, but it does have some differences. So let's take a look at some of them. So the first difference I want to focus on is the standard for instituting the action in the USPTO. So the AIA, this law that came into effect in 2011, changed the standard for granting a request. Before the AIA, in the inter-parties re-examination time frame, as I mentioned, the question that you asked when you filed a petition to the PTO was whether there's a substantial new question of patentability or not. So if the patent examiner decided that your petition did pose a substantial new question of patentability, then yes, you would get your IPX instituted and you would be off to the races. If not, your petition would be denied, and that would be the end of the story right there. Now, post-AIA, we have the IPR. And what happened was the AIA specifically outlined a new standard for the institution of petitions. And this new standard was a reasonable likelihood that the requester will prevail with respect to at least one of the claims challenged in the request. So supposedly this was a higher standard to meet. Substantial new question sounded lower, easier to meet. Reasonable likelihood that they will prevail sounded much higher, but that hasn't panned out in that way in practice. But we'll talk about that in a moment. That's the first major difference between the two. The second major difference between the two is that the time from petition to decision is very different. So for the inter-parties re-examination, the IPX, there was no statutory time limit in which you are going to get your decision, sort of like a regular litigation, so to speak. So you file your petition, it gets instituted, you go into this re-examination, this inter-parties re-examination process, and it could go on for a long time. There's no limit that was set by statute. In fact, according to the CRU, 95% of them were resolved within 80 months. Now, for those of you who have a hard time with math, like me, for instance, that means that 5% of these IPXs are longer than 80 months. That's almost 7 years. Or if you like being more dramatic, it's like over 2,400 days. In fact, you could watch all 3 seasons of House of Cards 1,477 times. Well, at least you can do that starting February 27th, since the 3rd season hasn't started yet. And then, yes, I am looking forward to that. Either way, that's a lot of Frank Underwood. And I do like Kevin Spacey, but that might be overdoing it for me as well. Now, IPRs, on the other hand, are statutorily limited to 24 months post-filing petition. So from the time that you file the petition to the time you get your decision, the maximum amount of time by statute in which you will get a decision is 24 months. Now, however, according to a study conducted by Harness-Dickey, the average time from petition filing to final written decision is actually much less than 24 months. As of the end of 2014, it's averaging out at around 16.3 months. So you can see here the difference between 80 months and 16.3 months is pretty significant. So what happens during this time frame of 2 months, or 2 years, I'd say, 24 months in the IPR? Well, let me walk you very briefly through the process. This diagram is actually from the USPTO, so you can go there and take a look at it if you want. But I'll just walk you through it very, very briefly. So first of all, you have the petition filed with all the things that I mentioned earlier. And in 3 months, the patent owner gets to put in a preliminary response. Okay, that's not all your evidence as the patent owner. That's just a preliminary response to the petition. And then no more than 3 months later, there's a decision on the petition. And it says no more than 3 months. Generally speaking, the PTO has taken, on average, about 74 days or 75 days. So almost takes up the entire 3-month period. And then you have a decision. So at that point, they decide, based on this reasonable likelihood standard, whether to grant the petition or not. And if the petition is granted, you're off to the races. And you'll see that there's kind of a dual track here over the next year. So it says no more than 12 months at the bottom. Well, that's a little bit of a misnomer, because the statute does allow for extending the decision up to 6 months for good cause. So really, that should say no more than 18 months, but you kind of have to request under good cause to get the extra 6. But for the sake of the argument, let's just walk through the rest of this diagram. You see you have motions, you have responses, you have an ability to respond by changing your claims, amending your claims to avoid some of the issues that were raised by the petitioner. There's oppositions along the way. And as you see on the bottom part of this diagram, there is discovery all along the way. Patent owner discovery, petitioner discovery, there's expert discovery, there's going to be expert depositions, there'll be expert reports, all those things. And then there'll be a period in which you can file observations and motions to exclude evidence, sort of like motions in limine. And then you have this oral hearing, which the hearing is set, and then the final written decision. So what does this all remind you of? I mean, it reminds you a little bit of litigation, doesn't it? I mean, you have briefs going back and forth. You have all this discovery going on in the meantime. You have a hearing. You have a decision. It sounds a lot like litigation. So you see there are some parallels between IPRs and district court litigations. Well, you're probably asking yourself, well, does this all matter? Are people even filing IPRs? Well, you bet your bottom dollar they are. So what we've done here is we've collected some numbers for you regarding the number of AIA petitions filed. That includes IPRs. And this is recent as of February 5th, 2015. So we got this as recent as we possibly could for y'all. You'll notice that the number of petitions for IPRs has more than doubled in 2014. Let me see, I can get my little pointer here. There it is. That's 2014. Maybe I can use, oh, technology is great. Look at that. 2014. There's 2013. You see, it's more than doubled. And then you can see that there have been more petitions filed in 2015, and you'll see that circled in red there, in just 5 weeks than there were total in 2013, and we're already halfway to the total from 2014. So you can see this is happening a lot. Now, IPRs are incredibly popular, and usage is increasing exponentially. So how does this compare to cases that are being brought in district court litigation? Well, I'm glad you asked. Okay. Oops. Okay. Matt, little help here? How do I turn this? Is that it? Okay. Sorry about that. Technology was cool just for a second. Now it became uncool. Here we go.
Are you okay? Need a hand?
Yeah, I think I'm good now, but we have 3 random dots here to distract everybody. I will delete that. There we go. All right. Back on track. So what we did here is we put some more numbers together for you regarding the number of patent cases and orders in patent cases that have been in the PTAB, which is the Patent Trial and Appeal Board, and that's the venue for IPRs of the USPTO, and in 2 popular venues for patent litigation, the Eastern District of Texas and the District of Delaware. Now, as you can see, IPRs are now more popular than even the most active jurisdictions for patent litigations. There were more IPRs than patent cases in either district court in 2014, and if you use the number of orders as a metric, and that's on the right side here, you'll see that the PTAB significantly outpaces all district courts. I mean, if you look at the numbers, it's pretty amazing. You know, on the number of court cases, 1,677 at the PTAB in 2014, that outpaces the Eastern District of Texas and District of Delaware. You see 2015 year-to-date, it's a little bit lower, but it looks like it's going to follow the same pattern. And if you look at the number of active orders, it's unbelievable. I mean, the number at the PTAB in 2014 was more than the Eastern District of Texas and District of Delaware combined, and that trend is continuing year-to-date as of February 12, 2015. So what this means is that you're going to see more and more of these IPRs pop up, and oftentimes in conjunction with related district court litigations. In fact, according to the same study I referenced earlier, about 81% of IPRs have concurrent related litigations between the same parties. 81%. So how does this increase in IPRs and this increase in IPRs and concurrent related litigations impact the litigation itself? Well, let's take a look. But before we do that, I want to show you this picture. So this is a picture of 4 terrific actresses and comedians, Kristen Wiig, Leslie Jones of Saturday Night Live, Melissa McCarthy, one of my personal favorites, and Kate McKinnon. Now, why do you think I have this picture of these 4 actresses here? Well, it's because they're the new Ghostbusters. I'm not kidding about that. They are the new Ghostbusters. So other than the fact that I totally love the Ghostbusters and that I think this gender swap of the Ghostbusters will be amazing, what does this have to do with IPRs? Well, reboots are always dangerous. People are usually pretty happy with the original movie, and you might end up losing the original audience when you reach for a new one. So you have to be careful that both can coexist peacefully and you don't make anyone angry. As an example, Footloose was remade in 2011, inexplicably, without Kevin Bacon punch dancing in the forest and doing gymnastics in an abandoned mill. Now, in my opinion, that was a huge mistake because that's one of the major reasons I liked Footloose. That and the Kenny Loggins song, which just sticks in your head. Honestly, you're going to be humming that song for hours now. And I was, at this point, going to play a little bit of that song for you, but I'm unable to do that. So instead, I'll just show you this picture of Kevin Bacon dancing, because that is a great dance move right there. I've used that many times. Okay, so some courts feel that the same way about IPRs that we feel about Footloose, or I feel about Footloose. They're essentially overlapping, but there can be some issues here. And some courts feel that even though that they're overlapping and they cover the same patents, there may be some issues with having them coexist. And of course, as lawyers, we want to be sensitive to that because we certainly don't want to make any judges angry, and we certainly don't want to make the USPTO angry. So the first thing to discuss is whether we can stay in overlapping litigation where IPRs are involved. So there are a number of reasons why you would seek a stay. So let's talk about that first. So let's say you have an IPR pending with a district court litigation. So what reasons would you want to stay? Well, number one, you might want the USPTO to review some critical prior art in the case, and that's something that could be very useful. You might get some potential resolution of discovery issues before you have to deal with it in litigation. You might be able to cultivate an admissible USPTO proceeding record because, of course, the proceeding at the PTO is admissible at trial. And then you might want to find a way to dismiss the civil action. Maybe if the patent is found invalid in the IPR, perhaps that would give you an ability to dismiss the underlying civil action. It might increase your potential for settlement as things are settled and decided at the IPR. And of course, it might reduce the issues and the costs of the underlying litigation, since IPRs, although they look like litigations, are a little bit more contained. Now, with that said, there are a number of reasons why you would also oppose a stay. And the reasons for opposing the stay are in kind of two buckets. The first bucket is avoiding prejudice. As your litigation is stayed, it can become stale. And that's, your witnesses start having dim memories. Your witnesses start disappearing and going off and working for other companies or what have you, and you have a hard time locating them. And more importantly, for those of us who are in the Hatch-Waxman space, you may exhaust some of your other stays. So for instance, in Hatch-Waxman, you might get this 30-month regulatory stay when you sue a generic who filed an ANDA. That 30-month stay might run while your litigation is being stayed, and that would be no good. You don't want to have your 30-month stay exhausted while you don't have an opportunity to litigate the underlying issues. The other issue is, of course, is there's delay in resolving the non-IPR issues. So as a reminder, the IPR can raise 102 and 103 issues. It cannot raise 101 and 112 issues. It can't raise issues of infringement. It doesn't address issues of obviousness type double patenting. Doesn't address issues of inequitable conduct. So there are a number of things here that cannot be addressed by IPR. So if you have your underlying case stayed, all of those issues are going to continue being non-resolved, and that can be an issue. You might want to push those forward in the meantime, even if validity or /invalidity is being dealt with at the PTO. So now that we discussed the reasons why you might be concerned about a stay, let's look at what standard is being used to get a stay when an IPR is involved. So in the past, there was some statutory authority for stays with a related USPTO action. But unfortunately, that's now gone, which leaves only the court's inherent authority to manage its own docket. Strangely, the AIA says nothing about what factors to look at for a stay due to a related IPR. So we're stuck with this traditional three-factor test from the case law. Now, what's even more strange is that the AIA did have a statutory test for stays related to what's called covered business method patent challenges. So that's what I refer to as CBMs. So that's almost identical to an IPR. There are some differences, but it's almost identical to an IPR, except it's limited to business method patents, so a certain type of patent. And it's interesting because why would the AIA, why would Congress in the AIA set forth a specific standard test, statutorily outlined test for how to get a stay in your litigation when you have a CBM, but not say anything about how to get a stay when you have an IPR? So to make things even more complicated, the test that's outlined for the CBM in the AIA has not only the 3 traditional factors from case law, but also adds one additional factor, as you see on the slide, litigation burden. And if you look at the congressional record, what it says is that the reason for the 4th factor is to place a very heavy thumb on the scale of providing stays. So it's very interesting. So what they're trying to do here is to encourage stays of litigations that run parallel to CBMs. But they don't say anything about encouraging stays that run in parallel of IPR. So that's a little bit confusing. So let's start first, though, looking at what these factors are. Let's look at the traditional 3-factor test first. So here are the 3 general factors that federal courts use when deciding to grant a stay of litigation. This applies all across the board and applies in the IPR context. Number 1 is whether the stay would simplify the issues to be litigated, otherwise known as issue simplification. Number 2 is whether the stay would cause undue prejudice or a tactical disadvantage to the non-moving party. And number 3 is what stage of the litigation you're in. Now, what makes this even more complicated is that courts have differed as to how much weight is given to each factor. It's almost a case-by-case basis. So it's hard to draw kind of a bright line or give you black letter law on this, or draw a bright line rule where you can say this is going to get you a stay and this is not. It doesn't usually work that way. So on top of all this, this haziness is this litigation burden, this 4th factor from the CBM that I talked about earlier. You know, the question being, is that 4th factor being adopted into IPR situations? Which is a fair question. Unfortunately, the answer is yes and no. You know, oftentimes when you see litigation burden discussed in the IPR context, it's absorbed into factor 1, the issue simplification. They say, well, you know, all this litigation burden context, these factor of litigation burden, really that's all issue simplification. And sometimes it's analyzed in factor 3, stage of the litigation. Well, the burden really is on timing, so we're going to analyze that from the viewpoint of the stage of the litigation. And confusingly, sometimes it's not mentioned at all. So it's not consistent. Sometimes it's being used and sometimes it's not. So as a cautionary note, please always check your district court's local rules regarding stays in IPR. You'd be surprised, but there are district court local rules that address a specific situation. Now, as an example, the District of Nevada local rules uses, and this is from something they put out, a 4-part test that mirrors the first 3 factors of the AIA 4-factor test. So what's interesting about this is that they refer to the 4-factor test as relevant to IPRs and CBMs, not just CBMs, which is clearly not what it says in the AIA. But they do it anyway. And then they create their own 4-factor test. And their 4 factors are, 1, the undue prejudice, so that's the same. 2, the issue simplification, that's also the same. And 4, which are different, 3 being whether discovery is complete, and 4 being whether the trial date has been set. Now, 3 and 4 appear to be more specific questions that fall under the stage of litigation, but they may also apply to litigation burden. It's a little bit unclear what they're trying to accomplish with that, but that's just something to be aware of. So note that it's not consistently applied, and then you have to look at it on a case-by-case basis, but you have to be aware of what factors to really hit, and you should always check your district court's local rules to be sure that they haven't addressed this specifically. So now that we've talked a little bit about the about litigation stays, now what's really different here with stays and IPRs as compared to stays and IPXs? Because you're probably saying, well, heck, they must have had litigation stays back then too. Isn't this the same thing as they've been doing for years and years with inter-parties re-exams? Well, essentially, with respect to issue simplification, you're right. There really is no difference there. IPRs and IPXs have the same amount of potential to simplify issues, so that usually doesn't change the analysis. And the stage of the litigation is irrespective of what process you have going ongoing at the PTO, so that really doesn't change either. But what about the undue prejudice? Is that factor weighed differently for IPRs as compared to IPXs? Well, I think it does, and let me tell you why. So I think that timing will make a significant impact on this undue prejudice factor. As we discussed, IPRs are statutorily set at a maximum of 24 months, cannot exceed 24 months, and as we talked about previously, on average are more like 16.3 months. Whereas if you're looking at IPXs, there is no limit, right? It could take more than 80 months. So on the factor of prejudice, and to the extent the court considers litigation burden, knowing that an IPR will end in 24 months may convince a court to stay a case and wait for the result. You can say, listen, it's only 24 months. Stay the case. 24 months we'll have our answer, and then we're back into the litigation. So it really won't stay anything for very long. There's really not a problem here, no prejudice. Now, on the other hand, the court may want to continue moving forward knowing that the PTO decision will likely come down before the case is ready for trial. So it might go the other way. It might be that the court says, listen, in 24 months, we're going to have the PTO's decision. If it simplifies anything, we're not going to be at trial yet anyway, so we'll go ahead and it'll simplify the case then. So there's no reason to wait. So, how does this really apply? I mean, I think that's a primary question, which will determine how the court views this factor for IPRs, is really how many non-IPR issues do you have in the litigation? In other words, is the IPR dispositive for your litigation? Because remember, infringements, 101, 112, OTDP, inequitable conduct, none of those can be part of an IPR. So the more of those that you have in your litigation, I believe the less likely your litigation will be stayed. Okay? So one thing is for sure, and that is, although close, more requests for litigation stays have been granted when a parallel IPR exists than denied, which means there's a real possibility that you'll have to deal with this issue in the future if you work in this area. You'll see that we have updated the statistics up to this morning, and 44% of IPRs, stays with regard to IPRs have been granted, 40% denied, and 10% granted in part or denied in part. You might say, well, how do you do that? How do you deny a stay in part or grant it in part? Well, here's an example, and this happens a lot, actually. You may have a temporary stay as the court awaits a decision on a petition. So it could be that you don't have an IPR instituted yet, but you have filed a petition for an IPR. The court may stay the case temporarily while the PTO decides whether to institute the IPR or not, to grant your petition. If the petition is granted, the court will institute a full stay of the litigation, and if the petition is not granted, the stay will be lifted. So that's an example of what is meant by granted in part or denied in part. And that happens actually pretty frequently in IPRs. It also means that here, all these statistics here, means that a key issue in patent disputes, patent validity, may be increasingly addressed in the PTO rather than in district courts. So because of that reason, we really have to talk about how these two routes really impact each other. And we have to compare them and talk about how they impact each other. So we're going to turn to that next. But before we go there, I want to show you this. So if you were or are a Breaking Bad fan, you couldn't be more excited than to hear that there was a spin-off coming. And if you're a lawyer, and I assume that most of you guys are lawyers, then what better spin-off than of Saul Goodman? If you watched the first couple of episodes of Better Call Saul, the spin-off, then you probably noted that he's a little bit different than he was in Breaking Bad. Now, I won't spoil anything for anyone, but the gist is that Saul ends up evolving over time based on his experiences, both legal and let's say under the table. Well, the IPR process has been around since 2012, September 2012 to be exact. So it has also evolved based on experience. Most importantly, it has evolved in the light of the overlap with district court litigations. Now, both are very similar, but defining how they're different has become the focus of jurisprudence over the last couple of years. So let's take a look at that. Let's take a look at the two venues and how they compare and how they're different. So I put together this chart here to talk about how these two routes differ. And I think that they differ in two primary areas. One is in burden of proof, and the other is in deference. And there are a lot of other smaller ones, but I think I want to focus on these two for today. So as far as the burden of proof is concerned, you see in the chart in the top left here, in the USPTO, there's no presumption that the issued patent is valid. Okay, no presumption. You have this, quote, broadest reasonable interpretation standard while doing claim construction. And for a challenger to prove invalidity, they have to prove it by a preponderance of the evidence. So, as you well know, more likely than not, so about 51%. In a district court, the patent is presumed valid. So you have that presumption in your favor if you're a patentee. There is no, quote, broadest reasonable interpretation standard in claim construction. And the challenger to a patent has to prove invalidity by clear and convincing evidence. And I like to think of that as more like 75%. So that's a pretty significant difference between 51% and 75%. So the second primary area of difference here is a question of deference. For the USPTO side, this is very interesting. I found this to be very interesting. Now, in court here, it can be determined that a patent you're challenging is valid, but that does not have a binding effect on the USPTO. I mean, they can still decide that the patent is in fact invalid. So having a district court say, I bless your patent, it's valid, or more likely it's not invalid, the USPTO is not bound by that decision. But let's flip it to the other side. Let's go to the courthouse. But if the USPTO determines that your patent is invalid, then it does have a binding effect on courts. So the PTO says your patent's invalid and the game's over. It doesn't matter what the underlying district court wants to do. PTO says it's invalid, and it's binding on the court. Now the basic premise is that you can have a patent that is valid in court because the challenger could not prove invalidity by clear and convincing evidence, so 75%, right? Yet they still have a challenger prove invalidity in the USPTO by the lower standard of a preponderance of evidence, so 51%. So in other words, they're trying to take into account this gap between the 51% and the 75%. So determining validity in court doesn't necessarily foreclose proving invalidity by a lower standard in the USPTO. So let's talk about both these in turn, because I think we should spend a little bit of time on this. Let's discuss the differences on the burden of proof first. So the first difference in the burden of proof is the claim construction, right? We said there are two different there's a different standard at the USPTO. At the USPTO, they have this broadest reasonable interpretation standard. District court does not have any such standard. So essentially, you can have two different claim constructions between the USPTO and the district court because there's a different standard at the USPTO. Now, that might sound like there's some sort of discrepancy there, but it turns out that very recently the Federal Circuit decided on February 4th of 2015 in the In Re Quizzo Speed Tech case that's cited there that this is okay. It confirmed that the use of a different standard for claim construction in the USPTO proceeding, just like the IPR, is fine and is in fact adopting the existing rule of broadest reasonable construction has been used in the PTO for years and years and years. In fact, they say for more than 100 years. Aside from finding that, aside from this finding on claim construction, the Federal Circuit in that case also confirmed that the Federal Circuit cannot review the USPTO's decision to institute an IPR, just the results of the IPR itself. Just kind of a side note there. But they're really taking a hands-off approach here. I mean, it looks like the Federal Circuit is, in a way, deferring to the PTO. So let's look at the second difference, and this is something that we talked about a lot when we talked about the chart, and we're going to talk about this again when we talk about deference, but I'll point it out again. The second major difference, of course, is proving invalidity, because at the USPTO, it's preponderance of evidence, and at the district court level, it's clear and convincing evidence. So that really does lead us to the difference between the both venues on deference. And that is really a study of this case in re Baxter International from the Fed Circuit in 2012. And it's interesting because this is the case that kind of set the groundwork for all that strange what happens if you find validity in one venue and you don't find validity in the other venue. What happens between the two? What type of deference do they have to give each other? So let's take a closer look at in re Baxter. So at the district court level, we have this competitor bringing a declaratory judgment action against the patent owner, asserting the claims in the patent were invalid and not infringed. Patent owner counterclaimed of infringement. Now the patent owner actually won on validity. They prevailed on validity at the district court. And then it went up on appeal in the Federal Circuit, and the Federal Circuit affirmed that decision. So now the Federal Circuit has said, yes, patent owner, we agree with the Northern District of California. Your patent is valid. So in this case, in the USPTO, there was a parallel reexamination. And the examiner found that on the same references provided at trial, it rendered the same challenge claims from the underlying trial invalid. So he's saying, I don't need any more evidence. I'm looking at just the references you provided at the underlying district court, and that tells me I can come up with a different conclusion. Now, despite the different outcome at the Federal Circuit, because as I told you, the Northern District of California was affirmed by the Federal Circuit, the board, Patent Appeals, affirmed the examiner's decision. So of course this went back to the Federal Circuit, and you would think, well, the Federal Circuit's going to be consistent. They're going to say, no, sorry, that I already said the patent's valid. It's still valid. Well, it turns out the Federal Circuit affirmed the board's decision. So now the Federal Circuit has come out both ways. They've affirmed the district court that the patent is valid, and they've affirmed the board that the patent is invalid. And they say, fundamentally, the PTO and reexamination proceedings in the court system and patent infringement actions take different approaches in determining validity, and on the same evidence could quite correctly come to different conclusions. So that's the gap, the 51% to 75% gap. So this decision obviously leaves patentees and challengers in an interesting situation, right? Because while determinations of a district court have full collateral estoppel effect in subsequent litigations, they're final, they're not necessarily binding, they're not final on subsequent administrative agency actions. Well, that sounds bizarre. And on the other hand, cancellation of claims by the PTO, an administrative agency, is binding on the district court. Doesn't seem quite fair in some ways. And actually, it's not without controversy. Judge Newman did dissent vehemently several times, saying that the majority ruling here destabilizes issued patents by ignoring the rules of finality. Perhaps there's more to come. Perhaps the Supreme Court will take a look at this and say, well, gee, there's a problem here. We should look at this very carefully. And Baxter did petition the Supreme Court to address these very issues, but the Supreme Court denied cert on May 19th, 2014. So it looks like we're not going to get any more clarity on the issue. So that is where things stand as far as deference. Now this is a picture of the A-Team. It's definitely one of my favorite shows. In particular, I really like the fact that Hannibal always said, I love it when a plan comes together. Yet his plan is exactly the same in every episode. I mean, let's face it, Face pretends to be someone else and he gets in trouble. Murdoch does something crazy, then he steals a vehicle of some sort. VA is scared of flying. Everyone gets into fisticuffs. And then the A-Team develops some contraption that shoots lettuce or something, and all the bad guys crash their cars without any serious injuries. And oh, by the way, everyone unloads about 2 tons of bullets into the ground because apparently no one has any aim. But there's actually no reason for this picture to be here. I just happen to like the A-Team, which is why it's here. So are IPRs all downside for patent holders? Well, not necessarily. Now, IPRs can help patentees. And I want to talk about that, because everything you've said to this point sounds like, wow, this is terrible for a patentee because it looks like my patents are all going to get invalidated. Well, it's not true. There's some upside here. So if a challenger is unsuccessful at the PTO, despite the lower standard of proof, the challengers are stopped in subsequent USPTO proceedings and subsequent district court or International Trade Commission actions from challenging the reviewed claims on any ground that was raised, no problem, right? That sounds like a regular estoppel, or reasonably could have been raised during the inter-parties review. Well, that's really interesting. So if a challenger on an IPR carelessly leaves out a ground that, quote, reasonably could have been raised, that challenger may be forever foreclosed from raising those grounds again, anywhere, in the PTO, in the court, or in the ITC. So take the wrong shot in the IPR, and that actually might hurt the challenger and help the patent holder. Something very important for a patent holder to remember. Now, aside from the estoppel, getting a favorable outcome during inter-parties review can also hinder invalidity challenges in pending district court litigation. So even though the burden of proof is different, a validity determination or a determination of not invalid in an IPR can actually provide proof that your patent is valid in a related litigation. And at least one court, the Procter & Gamble court, said that that was true. So IPRs can cut both ways. Let's go ahead and summarize what we've discussed here today. So here's a summary of some advantages and some limitations on IPRs. Now on the advantages side, as I said, there's a statutorily mandated short time frame, 24 months. There's no presumption of patent validity. There's a lower standard for proving invalidity, preponderance of the evidence. It may help to stay a co-pending litigation in district court if that's what you want. And early indications suggest that it's pro-petitioner. So in other words, a lot of petitions are being granted, and a lot of these IPRs are canceling claims. On the limitation side, a denial of the petition by the PTAB is not appealable. So that's something you really can't do. If you get denied on the petition stage, you're kind of done. There's very limited discovery in an IPR. There is some discovery, as we saw in the diagram earlier today, but it's much more limited than what you get in litigation. Denial of the petition may actually become trial evidence. So at least one court says that if you try to get a petition for invalidity and you are denied by the PTO, you can introduce that denial as evidence that your patent is indeed valid. And of course, adverse outcomes may become trial evidence. So if you go all the way through the IPR and, as we just said, you lose as a challenger, the patentee can use that adverse outcome as trial evidence of patent validity. Let me give you a couple of practice tips. And really the overriding issue here, the overriding message I want you to take home here is that you should take IPRs seriously. The PTAB itself has not disclosed any statistics regarding the results of IPRs. But the study that I mentioned earlier concluded that as of the end of 2014, around 80.9% of claims instituted in IPRs were canceled. 80.9%. Now, based on the study by another study, about 67% of IPRs whose decisions on the merits challenge all patent claims and validate all patent claims, resulting in a cancellation of the entire patent. So this is serious stuff. This can really impact a patent holder. It's not something to be taken lightly. Now, something that you shouldn't take seriously are tiny Pomeranians. On the other hand, you certainly don't have to take a tiny Pomeranian. You certainly should take a tiny Pomeranian seriously if you are Paris Hilton, who bought one of these for $13,000, which is very serious because that's a ridiculous amount of money for a tiny, tiny dog. But I digress. Back to IPRs. So some patent tips, some tips for patent owners and challengers. Okay, so let's walk through a few of these to kind of cap off the day for you. So for patent owners, conduct a pre-suit investigation now so that you know the strengths and weaknesses of all your IP, including where you might need to shore up evidence to support certain claims that may be challenged in an IPR. And remember that inequitable conduct and obvious type double patenting are not subject to IPR. So plan for that separately and consider taking steps at the PTO to correct those issues. For instance, like supplemental examination if you think there's an inequitable conduct issue. You should also consider whether a litigation stay would hurt or help you, and consider how that, as well as filed IPRs, would impact your ability to settle a case. And last, once an IPR is filed, consider if you can make the argument that other issues reasonably could have been raised, and thus are now stopped from any co-pending or subsequent action. Very important to consider that. Okay, so patent challengers. Okay, for patent challengers, the underlying message here is do your homework. Review all the IP you intend to challenge in advance and consider whether an early IPR makes sense. You can use IPRs to clear the way for your product if infringement may be a concern. And there are potential advantages to raising invalidity on your own terms at the PTAB instead of waiting for litigation, like the fact that you don't have to risk your non-infringement position. You obviously don't have to produce as much discovery. The burden of proof is lower to prove invalidity. And of course, there's no presumption of validity for the patent. Also, if you should consider if filing an IPR increases your leverage for staying a later litigation or receiving a favorable settlement. Those are things you need to consider. But beware, if you file an IPR, you have to be very careful not to give up unraised defenses because you reasonably could have raised them in the IPR. Now, careful review and analysis is necessary. All right, so that's all the content I have for you today in the time that we have allotted. I do want to give a little shout out to people who did help me with this presentation and who can help answer some of your questions. First is Chloe Zhang, a colleague of mine here at Fitzpatrick. That's her contact number and email. She's happy to field questions for you. And then Paul Kalish also helped out with this, and he's happy to field questions for you as well. My name, again, is Hakun Wong. Hakun rhymes with raccoon, so now you'll never forget it. It's with an H. There's my contact information, and there's my email address. I'm happy to answer any questions you want. And if you did not like my presentation, then my name is John Doe, and my number is 555-555-5555, and you can reach me at jdoe@jdoe.com, and I'll be sure to ignore you. Thank you very much, everyone, and I'm happy to answer any questions you might have.
Okay, well, thank you so much for that enlightening tour of both IPR and 80s pop culture. That was really phenomenal. We do have a couple of questions from our assembled company, so I'm going to pose them to you right now, if that's okay, Hakun.
Sounds great.
So, number one, was litigation final in Baxter prior to the USPTO's decision regarding validity? Doesn't the finality of the litigation have an impact on collateral estoppel with USPTO?
So if I understand the question correctly, we're asking about what the fact that in re Baxter, wasn't it already final with respect to the underlying district court litigation on invalidity, and why that in finality doesn't stop the PTO from coming out with a different decision. If that's the question, Judge Newman of the Federal Circuit agrees with you. She thinks that yes, the rules of the game are, once the Federal Circuit has said there is no more appeal here, this has all gone up there's no more appeals here, and I've decided finally that this patent is valid, then that's it. It's final. The party deserves the ability to rely on that decision. That's just the basic rules. That's how it works here. So this decision in re Baxter actually turns it on its head and says, well, yes, it's true, it is final, but the reason why it's not really final with the PTO is because it's a different question. Because the question that you're asking at the district court level is whether it meets the clear and convincing level of evidence and that makes it invalid. The question that you're asking at a PTO is whether it meets this preponderance of the evidence. So it's not really final with respect to the question asked at the PTO. It's only final with respect to the question that's asked at the district court level. Convoluted, it's highly controversial, but unfortunately we're not going to get much more clarity on that because the Supreme Court denied cert. But you're absolutely right, questioner. You and Judge Newman should get together for a cup of coffee and discuss that.
Okay. All right, so actually the questioner has added another comment. So in Baxter, I thought there was a still outstanding issue relating to damages prior to the USPTO decision, question mark.
Yes, yes. I'm sorry, so so there is this issue, so we're going to dive a little deeper here in Baxter. So if you want to go back to, I'm going to go back to the slide because this will be easier to explain. So you obviously have read Baxter because this is a very, I wasn't going to cover this because of the fact that this is one step further. But the bottom left box should really say, USPTO not bound by prior determinations of validity by Article 3 courts as long as there's one outstanding issue remaining. So you're right. There is an issue remaining, and that is a requirement that needs to be there. So you're definitely absolutely correct. Now, the reason why I didn't cover that is because the underlying issue that the reason why the Federal Circuit decided the way it did was based on this difference in standard on determining invalidity. But you're right. That bottom left box would actually say that. So I'm glad that we have someone on the line who actually is really well versed in this In re Baxter case.
All right, very good. So I'm glad that you mentioned that. I didn't realize that was such a deep dive question, but I'm pleased that you're able to handle it. Okay, so one final question before we wrap up. Over the years since IPR started, has the rate of stays on litigation increased or decreased over time?
So that's an interesting question because you would think that there'd be some difference. Now, in 2012, the rate of stays was about 2/3. It was 66%. But over the years, it's actually gone down a little bit, for 48.9% in 2013 and 41.8% in 2014. And then in 2015, year-to-date, it's a very small sample size. We're looking at 45%. But, it's probably going to even out at some point, a little bit lower than that. It looks like we're kind of reaching a steady state around that 40% to 45% mark of granted stays. But it's certainly, what it tells us is that a lot of these things are being granted one way or the other, although the rate is slowly declining, but I think it has reached a steady state.
Okay, great. And the final question before we go, you talk about different IPRs canceling claims for patents. Is there any difference between different kind of vertical sectors, say chemical versus manufacturing versus technology?
Yes, actually, it turns out that with canceled claims, it was in the technology side was much more prevalent to begin with, and then the chem and bio side. But it's actually kind of switched. As of the end of 2014, on the chem and bio side, 86% of claims that were canceled on the chem and bio side in the final written decision. In the electrical computer side, 82% of claims were canceled in the final written decision. And on the mechanical side, 74% of claims were canceled in the final written decision. So it's actually kind of flipped a little bit and gone the other direction. But really, I think we're looking at that 80% is probably about the right number, plus or minus 5. We're still seeing a significant number of claims canceled in IPRs.
Okay, and we did get, I don't know if we have time for one more, we did just get a last-minute question in,
Sure.
Which is, if there is a 60-page limit on the IPR, how do you make sure that you raise all the issues that could have been raised if you are limited by the amount of prior art you can provide?
Wow, okay, so you're asking specifically, how do you avoid this problem of including something that should have been raised because you have a page limit on what you can provide to the PTO in your patent owner's response. In the petition, not in the petition. And that's a very good question. I mean, it is tough because you're making a judgment call here. And the question is, if you don't have enough space to give it justice, then why should you assert it just to lose it? Because that doesn't really get you anywhere. I mean, then it doesn't really matter whether you get a stop later on or not, because you just basically asserted it just to avoid being stopped. It's tough. I think that is something. I mean, that's going to be something that the patent attorney has to consider very carefully. You're going to have to order. And I think what we do with IPRs, my personal practice, is I take all the arguments, and usually I have to admit I'm on the other side of IPRs. I'm dealing as a patent owner respondent, not as the petitioner. But if I were to look at the petitioner side and looking at what they do, generally what I see is they've ranked the arguments in terms of what they think is strongest, and they'll mention them all, and the last argument may only get 2 or 3 pages worth of airtime, but they'll give it all a shot. And generally what they'll try to do is they'll try to refer back. They'll say, okay, well, this area of 102 is the basis, but this area of 103 combines, including everything I said about 102 on this particular reference, plus this additional reference. So they'll try to consolidate their arguments in that way, kind of referring back to things that were said at 102. So hopefully that helps.
Sorry, yes. I think you've answered that as well as you can. I mean, it's obviously a very difficult question to answer. The situation is going to, determine how you approach that. We are at 3 o'clock Eastern. That does kind of conclude the time we have available today. I know that there are a couple of other questions. I would very much encourage everybody on the call, if you do have additional questions or clarifications, to contact Hakun with the email that he's provided, or I will make sure that everybody has an opportunity to get hold of his email. With that, I just want to thank you so much for a very, very lively and entertaining presentation, and thank everybody for attending. Hakun, would you like to say goodbye?
Yes, thank you very much, everyone, for attending. I very much appreciate it. Thank you, Momentum, for putting on a terrific an opportunity to get out there and talk to people about these issues. These are very real issues impacting patent owners and patent challengers all around the country, and it's going to continue becoming an issue into the future. So thank you once again. I appreciate it, and I hope to hear from all you soon. Thank you again.
Oh, and you just reminded me, we are running quite a number of IPR and PTAB-related events around the country. Next one's coming up in San Jose, but we've also got them scheduled for Philadelphia and Chicago for later in the year. You can find information about those at momentumevents.com if you are so inclined. With that, I want to thank everybody for attending today, and enjoy the rest of your afternoon. Take care and goodbye.